Okay, so we can really just understand that, states pretend that they have no obligation. It's just amazing, but it's amazing to me. So therefore, we're just going to have. Okay, so we can really just understand that, states pretend that they have no obligation. It's just amazing, but it's amazing to me. So therefore, we're just going to have. Okay, so we can really
Learn more at consumerfinance.gov. Consumer Financial Protection Bureau. One of four managing someone else's money. Considering a financial caregiver? Know your options. Is a loved one having trouble managing their money because of health problems or memory issues? Are you planning ahead in case you need help in the future? Knowing your options will help you choose. Inform a caregiver helps on an as-needed basis. If you need more than occasional help. Advisor. Trusted contact person. You can add a trusted contact person to your brokerage accounts. Some banks may offer this too. It allows your financial institution to contact the trusted person in certain circumstances, like if they believe you're getting scammed. Trusted contacts don't have access to your money. They get notified if the financial institution sees signs of financial exploitation. Convenience account. A convenience account or agency account lets you name someone to help you deposit or withdraw money and write checks. A convenience account is not the same as a joint account, where money is jointly owned and the joint account holder automatically gets the money when you die. A convenience account does not change the ownership of the money in the account or give your helper the right to keep the money when you die. The money belongs only to you. Speak to your broker or banker to see what informal caregiving options are available. Take this document with you. Next step. Learn more at consumerfinance.gov. Consumer Financial Protection Bureau. Two of four types of formal financial caregivers. Consider A. What is this? Power of attorney. This is a legal document that gives someone else legal authority to make decisions about your money or property. People often make power of attorney agreements so that someone else can handle their money if they can no longer manage their own finances. There are different types. Section A. Durable power of attorney becomes effective upon signing. Section A. Springing power of attorney allows you to manage your own finances as long as you have the ability to make sound decisions. Section A. Healthcare power of attorney gives authority to make health care decisions. Guardian. A court can name a guardian or conservator to manage your money and property if the court decides that you can't manage your money by yourself, and you don't have a power of attorney in place. A court can name different people to make financial decisions and health care decisions or give both roles to the same guardian. Trustee. A trustee makes decisions about money or property in a trust. The trustee can manage only money or property in the trust, not any of your other assets. A legal document called a revocable living trust gives the trustee authority to make decisions about money or property in the trust if you can't make decisions yourself. The trust also specifies who gets the money or property in the trust after you die. BA fiduciary or SSA representative. Payee. The Department of Veterans Affairs, VA, or the Social Security Administration, SSA, may appoint someone to manage VA or SSA benefits for someone who cannot manage their own benefits. That person is allowed to manage only benefits from the agency that names them. To manage other property or benefits, they all need one of the other formal financial caregiving arrangements. Next steps. Section. Find a local attorney at National Elder Law Foundation, NELF. NELF.org. Search or American Association of Trust, Estate and Elder Law Attorneys. Atila.org section. Consult your local legal aid office. LSC.gov grants grantee resources are grantees section. Visit Social Security SSA.gov payee for more information on the Social Security Representative payee role section. Visit benefitsva.gov fiduciary for more information on the VA fiduciary role. Learn more at consumerfinance.gov. Consumer Financial Protection Bureau. 3 of 4 choosing a financial caregiver. Review the questions below to make sure the person you have in mind to be your financial caregiver is the right person. Questions to ask when choosing a caregiver. Ask yourself, yes, maybe, no. Do I trust this person? Trusting someone with your finances, even in an informal way, is an important decision with a lot of responsibility attached. Do I feel comfortable sharing my wishes with them? Will they carry out my wishes the way I want them to? Conversations about money can be difficult. Make sure you can be honest with each other and that you will be able to discuss your needs and expectations. Are they willing and able to take on this responsibility? Ask the person if they are interested, able, and willing to help you. Avoid choosing someone who you worry may be struggling with their own financial problems, mental health challenges, gambling, or substance abuse issues. Will they make decisions in my best interest? Your caregiver should make decisions that are best for you and avoid conflicts of interest. They should include you in decisions as much as possible. Will they manage my money and property carefully? Your caregiver will need to keep a record of all money, property, and debts. Invest carefully, pay bills on time, and find out whether you are eligible for any government or employer benefits. Will they be able to keep my money separate from their own? Your caregiver should never deposit your money or property into their own or someone else's bank account or investment account. Will they keep good records? Your caregiver should keep detailed lists of everything they receive or spend for you. That includes keeping receipts and notes, even for small expenses. If you answered maybe or no to some of the questions above, you might want to choose someone else. Learn more at consumerfinance.gov. Consumer Financial Protection Bureau. 4 of 4 next steps section. If you don't have someone you feel comfortable asking to help you, there are money management programs that can help. To find help in your area, contact the Elder Care Locator. eldercareacl.governor section. Once you find the right person, consider choosing a backup financial caregiver or successor fiduciary. This is someone who can manage your finances if your first choice is no longer able to do so. For example, you might list your spouse as primary financial caregiver and a child as a backup. This is different from co-agents who manage the money together and consult on decisions section. Review who you chose every so often. Sometimes relationships change. If someone is not doing a good job as a financial caregiver and you no longer trust them, you may need to update your legal agreement to choose someone else instead. Learn more about financial caregiving. Check out the CFPB's Managing Someone Else's Money Guides, available at consumerfinance.gov. These guides may help you understand the roles and responsibilities of financial caregivers and help you consider who will best serve your needs in this role. Order or download free guides. Section. Agents under a power of attorney section. Guardians and conservators section. Trustees section. Social Security Representative payees and Veterans Affairs fiduciaries. 32021.
Wow. So that's what the federal government has actually done. I'm going to shrink that. Let's stop sharing the window. I have to stop share. Mhm. Just share that one. Go up here. A lot of people just don't even understand. Everything you need to have and everything you need to say is on Google. People say, oh, don't pay attention to Google. Did you go up here, USA.gov? It's where you find in everything. And then you should, yeah. And then yeah, here we go. See, guardianship comes from the federal department. Let's all listen. Gotta share the screen though. Stop the share. And share.
CB left navigation. Focus areas. Adoption. Child abuse and neglect. Child welfare services. Equity. Foster care. Guardianship. Title 4E Prevention. Tribes. Guardianship. Current as of June 30, 2024. The Children's Bureau provides funding to states and tribes that have been approved to operate a Title 4E guardianship assistance program in order to help them support relatives who become legal guardians of children from foster care for whom they previously cared for as foster parents. The following are additional resources on guardianship and kinship care. Child Welfare Policy Manual. This manual includes questions and answers regarding the Title 4E Guardianship Assistance Program. Infographic on implementation of Title 4E Guardianship Assistance Program. This infographic, prepared by the HHS Office of the Assistant Secretary for Planning and Evaluation, illustrates key facts about the status of the program's implementation. Resources for adult sibling caregivers. This Children's Bureau tip sheet provides general information about federal and state resources available to support adult siblings caregivers and kinship caregivers. This resource was co-authored by 2 of our NYTD reviewers.
Let's click on the link. Click, click, click. What does this actually do here? Well, I think we have to expand everything first. And because we're going to share the screen, then we got to select everything and do what? Let the computer read it because it is updated information. Let's select it all. And we're going to let the computer begin to read.
ACF Home Children's Bureau Law and Policies. Child Welfare Policy Manual CWPM Home 1, AFCARS 2, CAPTA 3, Independent Living 4, MEPA IEAP 5, Monitoring 6, CCWIS 7, Title 4B 8, Title 4E 9. Tribes. Indian Tribal Organizations. Search the Child Welfare Policy Manual, keyword policy area, select policy area, search additional resources, user's guide, withdrawn child welfare policies, references, print the manual, additions to the manual, deletions to the manual, modifications to the manual, cumulative change history of questions and answers, printer-friendly versions. This section, entire manual. Items that have been deleted can be seen by clicking the deletions to the manual link. 8.5 Guardianship Assistance Program. Browse by policy area -symbol. Question 1. Are children that are receiving Title 4E guardianship assistance payments eligible for Medicaid? Answer. Children who receive Title 4E kinship guardianship assistance payments are categorically eligible for Title 19 pursuant to Section 473, B, 3, C, in the state where such child resides. Source date August 12, 2009. Legal and related references. Social Security Act Section 473, B, 3, C, -symbol. Question 2. Do the fair hearing requirements in Section 471, 12, and 45 CFR 205.10 apply to the Title 4E Guardianship Assistance Program? Gap? Answer yes. The Title 4E agency must provide an opportunity for a fair hearing to any individual whose claim for kinship guardianship assistance available under Title 4E is denied or is not acted upon with reasonable promptness per regulations in 45 CFR 205.10. Source date August 12, 2009. Legal and related references. Social Security Act Section 471, 12, 45 CFR 205.10. 45 CFR 1355.30, p. 2, -symbol. Question 3. Describe the case plan requirements for children who have a permanency plan of relative guardianship. Answer. Section 475, 1, F, of the Social Security Act requires the Title 4E agency to include specific information in the case plan for each child with a permanency plan of placement with a relative guardian and receipt of kinship guardian assistance payments. The case plan must describe the following: 1. How the child meets the eligibility requirements. 2. The steps the agency has taken to determine that return to the home or adoption is not appropriate. 3. The efforts the agency has made to discuss adoption with the child's relative foster parent and the reasons why adoption is not an option. 4. The efforts the agency has made to discuss kinship guardianship with the child's parent or parents, or the reasons why efforts were not made. 5. The reason why a permanent placement with a prospective relative guardian and receipt of a kinship guardian assistance payment is in the child's best interests. And 6. The reasons for any separation of siblings during placement. If the child's placement with the prospective relative guardian does not include siblings, the case plan must also include a description of the reasons why the child is separated from siblings during placement. Source date August 12, 2009. Legal and related references: Social Security Act Section 475. 1. F. Minus symbol. Question 4. Which Title IV-E plan requirements apply to the Guardianship Assistance Program? Answer: the Title IV-E plan requirements that are not specifically limited to the Title IV-E foster care maintenance payment or adoption assistance programs also apply to the Guardianship Assistance Program under Title IV-E. These requirements are in sections 471, 2, through 471, 9, 471, 12, 471, 13, 471, 20. C. 471, 25, 471, 26, and 471, 30, through, 32, of the Social Security Act, and address topics such as agency organization and program administration, program audits and monitoring, confidentiality of information, fair hearings, interstate placements, school attendance and sibling placement. Further, departmental regulations at 45 CFR 1355.30 apply to the Title IV-E Guardianship Assistance Program to the same extent that they apply to the Title IV-E Foster Care Maintenance Payments and Adoption Assistance Programs. Source date August 12, 2009. Legal and related references: Social Security Act Sections 471, 2, 9, 471, 12, 13, 471, 20, C, 471, 25, 26, 471, 30, 32, 45 CFR 1355.30 minus symbol. Question 5. May a Title IV-E agency that is operating a Title IV-E Guardianship Assistance Program, GAP, claim allowable administration and training costs? Answer: a Title IV-E agency that is operating a Title IV-E GAP may claim allowable administrative and training costs for the proper and efficient administration of the Guardianship Assistance Program. Source date August 12, 2009. Legal and related references: Social Security Act Section 474, 3, minus symbol. Question 6. Is a Title IV-E agency obligated to reimburse the non-recurring expenses, NREs, e.g., legal fees, if the legal guardianship is never finalized? Answer: yes. A Title IV-E agency is obligated to reimburse NREs incurred pursuing legal guardianship, even if the guardianship is never finalized, pursuant to Section 473, D, 1, B, I, of the Social Security Act. The Act. A kinship guardianship assistance agreement must be in place with a prospective relative guardian prior to the establishment of the legal guardianship and must specify, among other things, that the Title IV-E agency will pay the total cost of NREs associated with obtaining legal guardianship of the child, to the extent the total cost does not exceed $2,000. Section 473, D, 1, B, I, of the Act. A Title IV-E agency may claim federal financial participation at the 50% rate for NREs incurred pursuing legal guardianship per Section 474, 5, of the Act. Source date October 14, 2011. Legal and related references: Social Security Act Sections 473, D, 1, B, I, and 474, 5, minus symbol. Question 7. Is a guardianship assistance agreement required between the successor legal guardian and the Title IV-E agency? Answer: yes. The requirements for a guardianship assistance agreement in Section 473, D, 1, of the Act apply to the successor legal guardian. Source date February 18, 2015. Legal and related references: Social Security Act, Sections 473, D, 1, 473, D, 3, C, minus symbol. Question 8. Are Title IV agencies required to have a successor legal guardian option? Updated June 4, 2024. Answer yes. Title IV agencies with approved Title IV guardianship assistance plans must include the successor legal guardian provision as part of their guardianship assistance program, and must amend their Title IV plans per instructions in ASIF CB, PI 1406. Source date ASIF CB, PI 1406. November 21, 2014. February 18, 2015. Legal and related references. Social Security Act, Sections 473, D. 1, 473, D. 3, C. Home, back, top. Please send all comments and web feedback to feedback.
Let's see what we have. But because this is child welfare. And I guess we just have to be expert at everything because I just can't see them following any policies that were created in America. So let's just monitoring. Let's take a look at this monitoring. We got to select all the text first. And then let's just read it. Okay. There we go.
ACF Home Children's Bureau Law and Policies. Child Welfare Policy Manual CWPM Home 1, AFCARS 2, CAPTA 3, Independent Living 4, MEPA IEAP 5, Monitoring 6, CCWIS 7, Title 4B 8, Title 4E 9. Tribes Indian Tribal Organizations. Search the Child Welfare Policy Manual keyword policy area, select policy areas, search additional resources, user's guide, withdrawn child welfare policies, references, print the manual, additions to the manual, deletions to the manual, modifications to the manual, cumulative change history of questions and answers, printer-friendly versions. This section, entire manual. Items that have been deleted can be seen by clicking the deletions to the manual link. 5.2 Monitoring. Title 4. Eligibility reviews. Browse by policy area -symbol. Question 1. Under what authority may the department review closed or sealed foster care records, particularly for those children who have been adopted? Answer Section 471, 8 of the Social Security Act. The Act requires a state plan to provide safeguards restricting use and disclosure of information concerning individuals assisted by the foster care and adoption assistance programs. It also indicates that a state plan must provide safeguards which restrict the use of information concerning individuals assisted under the state plan to purposes directly connected with c. the administration of any other federal or federally assisted program which provides assistance, in cash or in kind, or services, directly to individuals on the basis of need, and d. any audit or similar activity conducted in connection with the administration of any such plan or program by any governmental agency which is authorized by law to conduct such audit or activity, and the safeguards so provided shall prohibit disclosure, to any committee or legislative body, other than an agency referred to in d. with respect to any activity referred to in such clause, of any information which identifies, by name or address, any such applicant or recipients, except that nothing contained herein shall preclude a state from providing standards which restrict disclosures to purposes more limited than those specified herein, or which in the case of adoptions, prevent disclosure entirely, while the language of Section 471, 8d, provides that states may restrict disclosure entirely of adoption assistance records. That subsection, read in its entirety and in harmony with other sections of the Act, indicates that Congress did not intend to restrict access to federal auditors of information essential for audits under the Title IV foster care and adoption assistance programs. In particular, Section 471, 8d, itself provides for disclosure of information concerning individuals assisted by the foster care and adoption assistance programs for purposes directly connected with audits conducted by the federal government and otherwise authorized by law. The authority for federal audits of the foster care and adoption assistance programs is expressly provided for under Section 471, 6 of the Act. That section requires that a state plan, in order to qualify for federal financial participation, FFP, for foster care and adoption assistance, provide that the appropriate state agency will make such reports, in such form and containing such information as the Secretary may from time to time find necessary to assure the correctness and verification of such reports. The legislative history of Section 471, 8, also reveals that while Congress was concerned about providing safeguards which limited access to information on individuals assisted by the Title IV programs, it did not intend to hinder the essential function of federal audits. Thus, while Congress extended to states the option of imposing restrictions broader than those imposed in the past on the disclosure of information for the protection of the confidentiality of recipients of adoption assistance, it did not impede essential auditing functions by those authorized to conduct such audits. Accordingly, in the case of reviews of the eligibility of foster care and adoption assistance claims, the state agency must make available foster care and adoption records, including sealed foster care and adoption records, in order to document the eligibility of the beneficiaries, children, and related costs of administration. If the requested records cannot or are not made available, all payments made on behalf of the children whose records have not been made available for review and associated costs will be disallowed. Source date ASIF CBPA 8502, December 19, 1985. Legal and related references Social Security Act, Section 471, 6, and 8, H.R., Rep. Conf. number 96900, 96th Congress 2nd Session 44, 1980, minus symbol. Question 2. Since only states, and not tribes, are reviewed, how do we assure that Title IV eligibility requirements are met for children served by the tribes in foster care? Answer: states and tribes that enter into agreements whereby the tribes access Title IV foster care maintenance payments for children must determine between themselves how the roles and responsibilities for meeting Title IV requirements will be shared, while tribes that enter into such agreements with states have the latitude to develop their own procedures for satisfying Title IV requirements. The State Child Welfare Agency is ultimately responsible for the proper administration of the Title IV program and for assuring compliance. Children served by tribes who are receiving Title IV foster care maintenance payments as part of a state tribal agreement will be included in the sample of cases reviewed. Source date questions and answers on the final rule, 65 FR 4020, January 25, 2000. Legal and related references 45 CFR 1356.71 symbol. Question 3. Doesn't the requirement for the state to submit the complete payment history records for each sample case fail to comport with the regulation governing records retention at 45 CFR 74? Answer: there is no inconsistency between the requirement that a state provide the complete payment history and the regulation at 45 CFR 74.53, b, which, in pertinent part, states that financial records shall be retained for a period of 3 years from the date of submission of the final expenditure report. For a child in out-of-home care, the final expenditure report would not be submitted to ACF until such child is discharged from foster care. Source date preamble to the final rule, 65 FR 4020, January 25, 2000. Legal and related references 45 CFR 1356.71, b, minus symbol. Question 4. How will the eligibility of children receiving Title IV foster care maintenance payments where the state or tribe is operating under an IVE waiver demonstration be reviewed? Answer: we will not review the files of children whose Title IV eligibility would be affected by a waiver demonstration project. We pull a large enough oversample of cases for the Title IV eligibility reviews to exclude those children from the sample of cases reviewed. Source date: questions and answers on the final rule. 65 FR 4020, January 25, 2000. Legal and related references: Social Security Act, Section 1130, A. 45 CFR 1356.71 Question 5. Should the review Title IV foster care eligibility team include representatives that are external to the agency, such as state foster care review board members, child advocates, etc.? Answer: the purpose of the Title IV financial review is to assess payment accuracy through an examination of case record documentation. Those individuals identified above possess expertise that would be utilized more effectively on a review of service delivery issues, such as the Child and Family Services Review. The federal-state team combination is used to assist states in identifying strategies for training, technical assistance and corrective action, and to augment the knowledge of state staff about Title IV eligibility requirements. For these reasons, we see no benefit in expanding the review team composition to include external representatives. The state may, however, exercise its discretion in deciding the range of state and/or local staff to include on the team. Source date: preamble to the final rule. 65 FR 4020, January 25, 2000. Legal and related references: 45 CFR 1356.71, B, minus symbol. Question 6. For Title IV eligibility reviews, what is the expectation for determining whether a provider is properly licensed when a child is placed in foster care in another state? Answer: provider documentation requirements are the same for all children. The child must be placed in a licensed or approved foster family home, regardless of the state in which the home is located. The state must provide documentation that the home is licensed or approved and evidence that safety considerations with respect to the caretakers have been addressed. Source date: September 29, 2005. Legal and related references: 45 CFR 1356.30 and 1356.71, G. Social Security Act Sections 471, 10, and 471, 20. Title IV foster care eligibility on-site instrument and instructions. Sections H and I, minus symbol. Question 7. When a child is placed in foster care outside the state that has placement and care responsibility, must the foster family home be licensed by the state in which it is situated for Title IV eligibility purposes? Will it be considered an error case on a Title IV eligibility review if a foster family home is not licensed by the state in which it is situated? Answer: yes to both questions. In order for a child to be eligible for Title IV foster care maintenance payments, the statute requires that the foster family home or child care institution be licensed by the state licensing authority in the state in which the home is situated. Section 472, C. 1, of the Social Security Act. The Act defines foster family home as a foster family home for children which is licensed by the state in which it is situated or has been approved by the agency of such state having responsibility for licensing homes of this type, as meeting the standards established for such licensing. The definition for a child care institution in 472, C. 2, of the Act similarly requires licensing or approval by the state in which it is situated. See the CWPM Section 8.3a, 8c, QA number 2 for the situations in which a federally recognized Indian tribal licensing authority may license a foster family homes for Title IV purposes. If during a Title IV eligibility review, we find that a foster care maintenance payment has been made during the period under review for a child placed in a home or child care institution, not licensed or approved by the state in which it is situated, the case will be found in error. If we find such payments were made outside the period under review, the ineligible payments will be disallowed. Source date: November 14, 2007. Legal and related references: Social Security Act Section 472, C. Home, back, top. Please send all comments and web feedback to feedback.
Well. Now we know that there's really some regulations around foster care. And so we're going to take a break and stop the share. take a break and stop the share. This is all about what? Guardianship.